This is another live radio link-up brought to you by the Government Communications GCIS. GCIS. GCIS.
Time has gone 29 minutes just before the hour, 8 o'clock, and it's a very good evening to you and welcome to once again another broadcast brought to you by Government Communications and Information System, GCIS, on behalf of the Department of Justice, together collaboration. It's a collaboration between the SAPS as well as the NPA. My name is Karabalans. I'm glad to be spending some time with you this evening, and together we're going to be learning a little bit more about the Child Justice Act, Act number 75 of 2008. And this evening's broadcast really is the one that I don't want you to miss. So all parents, children, you're invited to this one. Guardians, teachers, law practitioners, etc. Please be part of this broadcast here. As you can see, those sounds in the background, those are my guests who are going to be joining us on the line, and they're ready and excited to go on air, and we're going to be chatting to them coming up later. Should you feel a need to call us in the studio, and maybe you have some questions that you would like to ask us, please feel free to do that. The number to dial will be 0800 142 446. I'll repeat that number again. It is a toll-free, by the way. So if you're going to be calling from a telecom line, you're not going to be spending a single cent. However, if you're going to be calling from a cell phone, don't worry about it. Our producers are willing and ready to give you a call back, in that way cutting you costs. So joining us by way of telephone is Lieutenant Nikiwe Hwayani, coming all the way from the SAPS, the South African Police Services. And it's a very good evening to you.
Good evening, Sen. How do you do?
I'm doing very well, thank you. Thank you so much for having taken some time to come and chat to us this evening. And also, we are joined by Mr. Joe Makume. He's a Senior Legal Administration Officer coming from DOJ, that's the Department of Justice. And it's a very good evening to you as well.
Thank you very much. Good evening to you and to your listeners.
So as a listener, should you need, as I said earlier on, to call us 0800 142 446. Let's not waste any further time, especially a lot of people will be flicking around trying to go and see what's happening between Orlando Pirates and Mamelodi Sundowns. Can I ask you not to do that? You can rely on me to tell you exactly what's going on. So as far as the scores are concerned and the progress of the game, we'll keep you updated here as well. So don't worry about it. Just keep on listening to this particular broadcast. So let's get into the program. Now, the Child Justice Act. Nikio, maybe let's start with you here. Tell us a little bit about it for those people who are not familiar with it. Lieutenant Hwayani? Okay, Lieutenant Hwayani, are you on the line? Okay, let's go to... can you hear me, Nikiwe?
Yes, I can hear you.
All right, let's start here. Let's start with the Child Justice Act. For a lot of people who are not familiar with it, do you want to just tell us a little bit about that? Where did it start? How did it come about and that type of thing?
Oh, okay, I hear you, even though you're a bit far. But if you hear me, we can carry on. The Child Justice Act, it's an act that was put in place by government to ensure that the children that are in conflict with the law, we're talking about children that may be suspected of having committed crime, that these children, we ensure that they are not treated necessarily as adults, and we find corrective measures that they do not go back to crime, and we try and correct their lives that they don't get to be hardened criminals. And the best way to do it is through Child Justice Act.
We've got what we call the Criminal Justice Act as well. Now, one would ask themselves, why is it necessary to create a separate justice system for children?
Like I said, the children cannot be seen as adults. And half the time when children commit crime, they either sometimes are not aware that what they are doing is crime. So it's for us to treat them differently, to find corrective measures, like I have said, to ensure that this child sees that what they've done is wrong. Mm-hmm. They see that what they have done cannot be done again. And if we treat them like adults, we expose them to hardened criminals. We actually saying to them, you can be a criminal. But if we treat them like children and we don't necessarily treat them like adults, it gets to be totally different.
Mr. Makume, one would maybe think after hearing this that perhaps we're giving children a bit of a scapegoat, and we isn't that like giving them sort of like they getting away with murder in inverted commas?
No, really, it's not like that. Remember, we come from a painful past where they were basically rights, but then none of our citizens in this country could enjoy those particular rights. And then with the coming into place, the new dispensation and then the constitution, because that's the supreme law of this particular land, then there was a Bill of Rights which enacted a number of rights, and then amongst which were issues that speaks to the rights of the detained, the arrested, and charged people. And later on, there was the birth of the Child Justice Act. It is not really correct that people or children are getting away with murder. It is actually a piece of legislation that is meant to assist our children. Because remember, nowadays, as soon as you have a criminal record as a child, then that particular criminal record is registered within the database of the South African Police Services. And then at some point, if, say, for example, you need to apply for employment within any government department, and now I'm told within the private sector itself, you then need to produce, you need to be cleared. Your name is basically checked against the database of criminals. Say, for example, you have passed your university degree or qualifications in finance and you need to work for a financial institution. The next thing they do, that particular clearance, they check your background, they establish that you have a criminal offense of theft. Then it becomes very much, actually, that then basically disadvantages you to say, but then how then can we employ you to work with public money? Or even how can then the government employ you in a to work with money in the courts, maintenance, bail, and so forth, when you actually have a criminal record of theft? So that now says, no, because of your past, then we are we need to be very careful not to employ a thief amongst ourselves. So this particular system, this particular piece of legislation now says, yes, we understand that as a child, there might have been some factors that has caused or that has led you to offending or to behaving in this particular way, such that you end up having a criminal conviction. So this particular piece of legislation is saying, for the period that we're still a child, there might be reasons that we can then condone to say, well, you basically did not know what you were doing. So this piece of legislation is saying, for the period that you were still a child, let us afford you the benefit of the doubt. Let us assume for now that, yes, there were these other factors that led you to behaving the way they would behave. So we are given a second opportunity. So in essence, what it all says is that, yes, during the time when you were still a child, you were still a young person growing up, you might not have known or realized the consequences of your conduct. So the criminal conviction, if you then have to grow up with it, then it will disadvantage you somewhere along the lines. And like the example that I've cited, you cannot therefore then get employment from government. The piece of legislation is say all those particular convictions that you might have gathered as a child, then you have an opportunity that you can then apply after 5 years to have them quashed, and then you start on a clean slate as a responsible citizen of this particular country, because we don't want to be seen to be raising a country full of criminals. Where will we go? We are a constitutional democracy, so we need to have children basically growing up under environment that is, or growing up under or in a country that basically recognizes and appreciates that they are children, and then they are likely to offend. And then having offended, then there need to be a system in place which then tries in some way or another to accommodate their history as children, and then says, as soon as you enter into adulthood, then this is basically what we expect from you. This is the type of behavior that we expect from you.
And Obviously, that takes us to the whole thing about expunging, and we're going to be talking a little bit more about that coming up during the show, so it'll move an inch. But before we do that, here's Patco. You're calling all the way from Aliwell North. It's a very good evening to you, Patco.
Menikiwe lindate jo makume ka mona abuti nna ke batla o tseba di ba itiba ha mo studio ke batla o tseba mabapi le act ena ke ba kana ka tsatsi lena ne batho ba letse the community ba ile ba involve na abantse ba qeta ho etsa act ena ya bona ka fumana hore tulong tse ding like bo the rural areas batho ba bangata ha bana tsebo ho hang ba qala ho utlwa tsa tsingena la ka sheno tulong tse ding mhlala mo o tlo qabitisa tulong tse tshwana le bo Steak Sprite bo Lady Grey le bo Battle East ke potsa ke apile ena potsa ke wa bedi ene ka tsa o tseba hore ke mang a etsa decision o act ena mhlomong ngwana o ile aba I suppose mhlong a utswa fumana hore no wa hlaela heno a sale moholo di criminal records wena o ile wa utswa ding le itseng kapo o ile wa tshwatsa ntong e itseng e ka ba ke mang a etsa ntho decision hore ngwanena heno o tshwanetse hore a siwe leseng la ntshotho la di-social workers kapo re tla mbeya tlasa leihlo la batswadi ba hae le hore a be yena time and again re tla re di mapolisa ka bo social workers re yo msheba ngwane hore o ntsa latela na punishment din I like fumana mhlomong o courting ya hore okay o tla community work ke potsa ga video potsa ga raro ne ba tla tseba hore o na le di cases mana hore bana ba qabana sekolong since again editing ha ba qota o qabana emong o hlaba emong sekolong ising intention hore ona batla mo lema tsa fumana ba tswa ba ngwane ba tsamaya bo bulanyewe o twa mono bana he a ba hlaela le khutleng la dinyewe o fumana emong o kopa tshwarelo ha ba kopana strateng o fumana gore e ba conflict hape no ha ba sa shebana hantle di metswalle e ba involve le yona e ka ba ntho jwalo e thijola jwang ke a leboha una bokarabo e ka melo tabolani community radio wa Sundowns.
Yeah, ke le Sundowns ka net, and definitely we're going to be giving Pirates a hiding, so brace yourself for that. 18 before 8 o'clock, and I'll be keeping you updated with regards to the Orlando Pirates taking on Sundowns. I'll be giving you the scores, so please don't move away trying to go and watch the game. Stay here on this broadcast. We'll keep you updated with regards to that. Here comes Patco asking 3 questions. The community's consultations, were they done with regards to the act? And obviously, and then after that, one thing that he would like to know as well is the education processes to make sure that communities understand this act. What are you guys doing about it, Mr. Makume?
All right. Kale wa mrenak. Tlokale ka dikarabo tse butsitseng kapa tlokale ka ya o qetela. Ha re ta motabeng ya education part of it. We run a lot of we have been and then we are still going to run a lot of awareness and public education campaigns as far as this piece of legislation is concerned. At the moment, like we are now speaking to you, this is part of the education and awareness on this piece of legislation. We have done that with some other public broadcasting stations. We have been doing that prior to 2010 when the Act basically had to come into operation. Post 2010, we have basically printed out with a lot of national publications, that is now your newspapers, what the piece of legislation speaks to, and then what is it that it is all about. I've been myself to television to speak about this particular piece of legislation. I've got colleagues at National Office, that is now in Pretoria, and other provinces who have been basically busy doing some public and awareness campaigns on this particular piece of legislation. We have had a number of imbizos at all our public outreach campaigns that we as a region, Gauteng, and I know across the board as a department, we have basically tried to cover as much as much ground as possible to educate our public out there about this piece of legislation. Yes, to some extent, some people say, yes, those guys in the rural areas might not be aware of the piece of legislation and what it basically says to them. We have embarked on that. Hence, currently, this particular radio talk shows, we are currently concentrating mainly on on community radio stations to basically speak on this piece of legislation. A number of stakeholders, depending on the role that they play on this particular, in the implementation of this piece of legislation, then we are trying everything in our power to sort of educate our public out there. And then this is not going to stop. We are only in the second year of implementation. This particular piece of legislation will be for us forever. We'll then continue to do it as much as we have done with other pieces of legislation. Dipotso tse ding tse ntata di butseng ko rena karolo e bapetsweng e be na hula bana le di consultations
ke na ora na ho kile wa ba le di public consultations na batho ba ile ba bolellwa ka ba ile ba bana le seo ba se buang mabapi le act ena
ke nete ho ile ba jwalo ha fuwa batho fuwa monyetla wa hore ba ke ba tlo supporta ka ba batla mamela hore molao ona o bua ka ebile ba fuwe sebaka sa hore ebe ba na le di objections ba le kgatlhano le molao ona ka pa dikarolo tse dintse itseng tsa molao ona ba kgone ho ipelaetsa ho etsala ka molao molomo o etswa mo Afrika Borwa hang fela o qeta o pele o tsamaya o gazetiwa ho bana le ntho tse bitswang di public consultations batho di bakeng tse fapaneng di province ho bana le dinako tse ka ntseng tsa hore ba biswa ba jwetsa hore ba tle parlamente e tla bathong ho atla ho discussiwa ho nkwa maikutlo a batho ho kgutlela morao ho lo discussiwa ntlha tse batho ba di buileng malebana le molao onana tsamaiso ka nyeno ka ba process ka nyeno ila ya etswa jalo ka etswa molao o molomo wa rona ka re di province ka fela tsona tsa e robong kana le parlamente ngutso discussitswe ha bana le di opposition parties ha bana le megatlo e ipelaetsang kgatlang le section tse dintsi tseng pele bo tsama o saena ke mo president or ebe molao wa Child Justice Act ho ile ha bana le process ka nyeo ya karetsa manga pa mang hore ba ntshe maikutlo hore ha molao o qala o ba teng ho ska mala batho hore ha re o tsebe ebile re kgatlang lona ho ska be se o hla eka ka pa bona le ka kona batho o hlahang ebile diteng tsa teng batho ba di tsebe mohlomong ho ya lefela hore ntate o founa le kae ha eba mohlomong ha ka tseba fela hore molao o molomong pele o fitsa parlamenteng ho bana le monyetla hore batho ba ahi ka kakaretso ba tle ba tlo ipelaetsa ba ntsha maikutlo a bona ho ya ka mo leng ka teng ebile ha ba nna le ntlha tse ding mohlomong ditsinyo tse ntjha tse banana ba batla hore di akaretso ka ro molaong ba fuwa sebaka se kang seno o butse putsong hape ya hore ke mang a nka nqeto hore ho etswa jwang ka ngwana mohlomong a ileng a tshwarela case itseng ho etsala tjenana hang fela ho bana le motho a tletlebang ka case hore hona le bohloko tse bo etsaetseng kgetla pele fela motho a tletlebang motletlebi o ya police station ya o fina le yena o ya o lo etsa case ha ke ta bula case o bula docket mo docket eno ka tsa le latelang ya nkiwa le jwalo iswa mo mothuthisi o tholala magotleng a rona a dinyewe ka rona mothuthisi o tla bala docket eno a ba le statement sa motletlebi haeba no sentse hona le statement tsa dipaki le tsona o tla di bala kaofela a tsona a nke qeto ho ya ka mo a rupiletseng ka teng dithutong tsa etsa semolao hore ebe na case ebe ha se case re kanang ra ebe ya ka thoko kapa ra ke ra itlisa ka rolo khotla dinyewe ika ebe ha se case mohlomong motho ka re mona ke phoso ngwana ona sa tsebe ka nnete ntwa etsa ke ntho le re bitsang hore mothuthisi o etsa decision making with madoket ka nyino case tse ngata tsa ka re tsa bana boholo jwang ha re tsikila holo duma molao ona wa Child Justice Act ba thuthisi ba bangata ba di beela ka thoko process eo e be re bitsa re ke diversion ka mantswe a mang bana ba ho tholwang hore ba qualify ho ya ka mo etsa lo etsa etseng ka teng ba fuwa monyetla wa hore ba ke ba ithute ho duma diphoso tsa bona ke mona mo tlabeng bana bano ba referiwa kapa ba romelwa lefapheng la social development ke mo batla kopanang teng di social worker ba re ba bitsang di probation officer ke social worker tse rupeletsweng le tsona hore di kgono tse ba hore bana ke batho ba mofuta mang ebile ha batho ba qeta ho thola docket tse kantse ka ba qeta ho tseba ka case tsa mambana ba fuwa sebaka se eno sa hore ba kopane le ngwana pele o fela matsatsi a mabedi kore within 48 hours tshwantse probation officer e so kopane le ngwana e entse ntho re bitsang assessment ka mantswe a mang wa ya ha bo ngwana a kopane na mo interviewe a kgone ho tlisisa hore hantle ke ntho mo susumeditseng hore a tlole molao ka ba itshware ka mo ileng a itshwara ka teng ha eba ngwana o kwaletse o tla ho yena police station kapa o tla dibakeng tsa social development tse re di bitsang ke di child and youth care centers into tse kang ha jwale tjenana tlamo se diranang ka ro Gauteng ho bitswa bo Bosasa hona le bo Dr. FNF Ribeiro kwa kantle ho Mamelodi hona le bo hona dibaka monana Pretoria social ngube mola tse bitswang Fathers Mangaliso Mkhashwa mo bana ba kambano ba romelwang teng hang fela ba ka tshwarwa ke maponisa kana go ya 48 hours social worker e tla etsa reporto e hlalosa hore boemo ba ngwana ke ofe reporto e ne khutlela mothuchisi ha ka tobala report e tswang ho social worker o nka teto hore ka nnete e ha se case e re kana ra senyana go ka yona ra nna ra isa morao ka makgetho a mangata ka mora 6 months e belona re tla re tlo e bua ngwana yenona o kena sekolo ha re batla mo seitsa nako o entse phoso re amohela ka mo dintho di etsetseng ka le yena o tla be se hona statement sai sentse ke provision officer hore ka nnete o ikutlwa jwang ka botlhoko tsebe bona ba wentseng kana go engwe ka bakala rona le batswadi kana go e social worker tla be le teng go tla hlaela mo le hore ka nnete se sosa ke eng hore ho be ho ile ha bana le tlolo molao e kanyena ka ba ibe ngwana o ile itshwara ka tsela itseng ke teng mo kenyang batho ba a mehang kaofela ho kenyeletswa le e motletlebi wa le yena se ba tshwantse ba ye ho yena ba lo mmotsa lena maikutlo a ke a feng e bena ka nnete a ka thabela re ngwana eno a qetelle a le lekgotlela dinyewe ibe nga bona molato qeta ile tšhanganeng ka ketso kapa ka tlolo molao e wa entseng ka moratso o tle ha qeta o lekolwa mohlang case enana e kgonang ho fitla lekgotlela dinyewe ke mona mo magistrate kapa mo motšhutšisi a tla jotsa magistrate teng hore ha qeta o bala re be re utlwisa boemo ka kakaretso re ntho kapa tlolo molao ena e ngwana go swang ka yona e etsaetse ka tla somaemo a kang afeng re nka qeto rona jwale ka re le batšhutšisi e le rona re nka qeto hore ke case efeng e tshwanetse e tle ka ro lekgotla dinyewe ke efeng e tshwanetse re divert re nka qeto hore case e ha e deserve ha ya tshwanela hore e tle monana re tla tlo e bua monana re kopa hore ngwana a fuwe chance re divert ya tswa ka ro lekgotla dinyewe ngwana o iswa di social worker hobane kana go ba etsa report ba tle ba se ba entse le reporto e recommendang hore ke program e fenye ngwana tshwentse a tsamaye hore tle kgone mo thusa kana go ngwe dingatanyana di program tsa ile tsa hanka fana ka mohlala engwe ya tsona ke ya anger management kana go ngwe o na kwatile a be a tlapa ngwana e mong ka tle jwalo ngwana e ka nyeno se a thuswa hore a tsebe hore o tshwentse a control ka pa laole maikutlo a hae ha eba hona le ngwana mo kwatisang ka tla sa mabaka itseng a tsebe hore tshwentse itshwara jwalo ka ngwana a kgone ho fana ka sebaka sa hore a tla kgone hore a thuse hore le yena ho holeng hae a tsebe hore ha se batho kaofela ba tla dumela le yena jwale ngwana ka nyeno ha qeta o debetua e tla fuwa mohlomong kgwedi kapa go ditsepedi o ya lefela hore botelle ba program ya teng ke bo bokae ka mora program eo kapa ka mora nako eno o tla gutla ngwana a gutlisetswe le go tlela dinyewe kapa o tla bana le report e tswanya hore ka nnete o ile attenda program ka matsatsi a neng a beetse hore attende ka ona ibile rona re le social worker re gotsofetse hore ngwana o kgone ho ithuta go itseng go laola maikutlo a ibile re kopa le go tlela dinyewe le khale case ena case eno e fitla go tlela dinyewe motšhutšhiso tla ba sa jwa magistrate rona case ya ne le mo go tse tharo tse fitileng re hulela morao ngwana go nne re attende program e itseng ka katlego ibile re kopa hore e tlowe ka tsela jwalo ngwana la ka ba a ne a kusitswe ha hona ka mo atla bana le ntho re bitsang previous conviction gore ha no ba le tlolo molao e fitileng eo e tla mo senyetsang bokamoso jwale ka se ke tlhalositse ya kala hore ha ona previous conviction go ba le bothata ba hore mmuso o hire ho ya lefela hore previous conviction ao ke fe jwale ka tsela jwalo ke ka mo ngwana tla thusa ka teng motho an ka ntseto fela tloa fatshe ke mothuchisi ho ya lefela hore mabaka ke a fe ibile nka tlhalosa ka o tla tseletsa fela hore mothuchisi ha se di case kaofela tla di beya ka thoko kapa tla di divert ho ya lefela hore tlolo molao e ntsweng ke ngwana e serious ya kae ha eba ke ena e serious to fana ka mohlala ha eba ke apeto ene ho sa utlwa le hantle ho etsa jwang bathuchisi ha ba rate hore case ka ntseno ba di bele ka thoko ngwana e molemong a entseng tlolo molao ya e batlang e le serious ka fela tsona bana ba ka mbano ka fela bona ba fuwa sebaka sa hore ba kene ka re le khotlela dinyawo ka re le khotlela dinyewe process ya lekgotla la dinyewe e tswele pele ha ba bona molato ba kgona ya tjhankaneng hobane ga ona ka mo ba ka divertwang ka teng hobane tlolo molao e ba yentseng e serious haholo ebile ha o sheba ditokelo tsa motho a hlekefeditsweng e tla ba ha re kgathalle ebeng case ka ofela tsa bana se tsa mofuta wa peto e tla bewa ka thoko potso o qetela hanga feta fela ka pelenyana ho yona ebe ngwana ba lwanne ka tsela jalo mo a mo lematsa jalo ka sa hlalositse ebile ho bontsha hore o a hlekefeditseng mo hlekefetswa o na le o ikoba ebile o ikopa maitshwarelo re na le ntho ngwe bitsa restorative justice ka re ho criminal justice system ke mona mo reng batho ba qabaneng botshetse ba fuya sebaka sa go ba dule fatshe ba bue ka tlolo molao e entsweng ke e mong kgatlhano le e mong ka tsela jwalo e o kenyeletsa hore ho bene le o mong a tla ikopa maitshwarelo ha foseditse e mong ka tsa mabaka a entseng gore botlolo molao e ka nyeno e be teng ka tsela jwalo re kopanya ba lelapa la ha ona a hlekefeditsweng le lelapa la ena a hlekefeditseng gore the victim and the offender ba kopanywa hona le ntho tse bitswang the victim offender conferences ba dula fatshe ho bua ka tlolo molao enana ho bana le program hape jwale ne ke dusitse ka taba ya diversion ho bua ka tlolo molao eno qetelong o mong ha e ka ba mohlomong ha ba utlwane ka hore ho be le tjhelete e patalwang ho hlatswa e mong matso ho bana le hore ka nnete ha o ka kopa maitshwarelo fela hona ke tla be ke kgotsofetse so boemo bo kang bono ba etsahala holo jwang bana ba qabana dikolong department ya education ya re thusa le ona hore bana ba kang bano ho bane le mekgatlo ikemetseng re ke di NGO di teng tse tsamayang dikolong tse thusang dikolo tse itseng sebakeng se itseng ha ona le mathatanyana a kangana hore bana ba kgone ho tseba re tshwanetse ba phele jwang jwale ka le bana ba ske bana le di-case e re ha selemo re le mo re leng teng a tshwanetse bana ba ngole di-examination e bontse na le bana ba lwetse matha makgotleng a dinyewe ba lebetse ho mosebetsi wa bona gore ba kene sekolo ba kgona ho qeta sekolo ba tle ba tlo sebetsa ile ba nke maikarabelo ntho a bohlokwa ke hore hoduma restorative justice principles tse setlileng haholo tsona ke yona eno ya re motho e mong o tshwanetse a dumele tshwanetse a nke maikarabelo accept responsibility hore ka nnete ha ka etsa hantle mohlanganeng a etsa eng a hlekefetsa motho ngwe ebile o kopa maitshwarelo ke tsona ntho tsa bohlokwa tse re di shebang haholo hore case ka nyeno e qetele ntshitso ka re lekgotla dinyewe ebile e bua ka thukunyana mo malapa a kopantsweng social worker kapa social worker tse sebetsang di NGO hore ho ba le tharollo ma mathata a ngano ke a leboha.
2 minutes before 8 o'clock, you're listening to a special broadcast by Government Communications and Information System, GCIS, together with the Department of Justice, collaborating with the South African Police Services, and not forgetting the National Prosecution. Down, so is Sundowns. It looks like they're not... yeah, let's move on. 0800 142 446. So that's the number to dial. But producer is a Pirates fan. You should see he's almost about to throw a party on the other side of the studio. 0800 142 446. Telephone number in the studio if you've got any questions that you would like to ask. But please don't ask me who scored the Pirates goal. I'm not going to answer that. You can ask me anything that's related to the Child Justice Act. That's exactly what we're talking about this evening here. Lieutenant Wayani, when it comes to the expunsion, the processes that are undertaken there, and how long does it take? Do you want to tell us more about that? Lieutenant Wayani? Nikiwe? Nikiwe, are you still there? Okay, looks like we are battling to get a hold of Nikiwe there. Would you like to jump in there?
Yes.
Yeah, the processes that are undertaken as far as the expunsion is concerned, and how long do those processes take?
Right. Kelly wondered. Process ya expungement is sebetsa ka tsela e. Ho ya ka molao wa Child Justice Act.
Mr. Makuma, beg your pardon. I'm just feeling in the interest of other listeners. Do you want to maybe explain that in English, please?
All right. Thank you very much. All right. Thank you very much for that. The process of expungement actually has always been there, but now in the past, or mainly, it has always been recognized under the Criminal Procedure Act, which is an act of 1977. So it operated in this way. One will get convicted today, which is now the 7th of November 2012. Then what the law had basically prescribed then was that before you can apply for expungement, you then have to wait for the next 10 years. So that will now mean anyone who gets convicted today, he or she needs to make an application for an expungement of a previous conviction or of a criminal record, he will then have to wait until the 8th November 2022. That is basically as far as the others are concerned. And within this particular 10-year period, that particular applicant must be clean. In other words, he should not be arrested and charged and convicted of any crime in between. In other words, it must be a 10-year period with clean hands. So as far as then the Child Justice Act came into operation in 2010, and then it brought through a system, a child justice system now for children. What it all says is that if a child gets convicted today for whatever crime, then that particular child does not have to wait until 10 years later. That particular child, as soon as the sentence has been served, can make an application 5 years after. Actually, the child does not even have to make an application.
Yeah.
The record gets automatically expunged 5 years after the conviction. In other words, if the child is convicted today, then the child will then have to wait up until the 8th November 2017 to have that particular record cleared. If that is not cleared, we can then, we as a Department of Justice, we are the custodian of that particular process. We have the necessary forms that we can assist with to have that particular conviction expunged. And then as soon as everything has been documented and has been filed with our national office, then 3 to 4 months, that particular record will then be done away with. But then for the applicant to qualify, there will need to be a clearance certificate. That is now the applicant proceeds through to the police station, nearest police station. The fingerprints are taken from the applicant, and then that is now by SAPS. They check it against their criminal record database, and a clearance certificate is issued to confirm that indeed Joe Makume was convicted of assault on the 7th of November 2012. That particular record, then that particular certificate needs to be attached to the application form that the applicant will then have to complete. It is submitted to our national office, and the Director General of the Department of Justice has a final say in terms of deciding whether the applicant criminal record can be expunged or not. But then she is the decision maker, and only upon a decision being taken, then does her office then engage the criminal record center of the SAPS to say this particular applicant has applied and then has been successful. Please, within the next 7 to 14 days, clear his or her name, remove his or her name from your database, because the criminal record, the application has been approved, and then that is basically how the process unfolds.
0800 142 446. That's the studio number should you want to be in touch with us. Perhaps you've got any questions that you would like to ask us. You're more than welcome to do that, to use that number. It's a toll-free number if you're going to be calling from a landline. Otherwise, if you're going to be calling from a cell phone, our producers will take your number down and they'll definitely call you back, cutting you costs. So do that. And don't miss out on anything that we are talking about this evening. Perhaps you've got some questions that you've been battling with for quite a long time. I've got the two guests here over the phone. It's Joe Makume, Senior Legal Administration Officer at the Department of Justice, as well as Lieutenant Nikiwe Hwayane, and she's coming from the South African Police Services. It's a big thank you for them for making some time to come and chat to us this evening. Nikiwe, maybe let's jump into the processes of arrest. Now, one can ask themselves, are they the same? The process of arrest to children and the processes of arrest to an adult, are those processes the same?
Definitely not. The Child Justice Act, if you go through it very well, it tells you that it's not necessary to arrest a child Like Mr. Magume has just explained earlier, that the statements can be obtained from the complainant, the statements can be obtained from all the witnesses, and all evidence can be gathered and be presented to the prosecutor. The prosecutor will then go through the docket and decide if for some reason that child that has committed that crime needs to appear before the court, a summons would be issued for the child to come and attend the court. Otherwise, the child can be taken through the diversion that you were speaking about. It's not really necessary to arrest the child. If for extreme circumstances a child has to be arrested, for an example, if a child we suspect it would he's a danger to himself, we will. But also we look at the age. There is an age where we decide we're not going to arrest altogether. And also the arrest will be informed by a lot of factors. If we do arrest, we make sure that the child we keep separate from adults, and we keep boys separate from girls, and we arrest the child at a minimal time to make sure that the child appears before court as quick as possible. I must emphasize, it gets done as a last resort. We can do everything. We can consult the probation officer to come and assess the child to ensure that the docket is at court. But arresting a child, we try by all means not to arrest the child. As for an adult, if you commit a crime now, we find you now. We fill in all the forms. We do take statements and we arrest you. But the child, we try by all means not to make the child slip behind bars.
Coming up later, we're going to be hearing a clip. Then it's a reflection, really, of children living on the streets and their experiences as far as being arrested and that type of thing is concerned. How do they feel? What do they say? We're going to be hearing it coming up later. It's 7 minutes after 8 o'clock, 37 minutes into the game, and Orlando Pirates are still leading 1-2 Sundowns, not having scored a single goal. Guys, please. Do us a favor. You are causing trouble here with my producer. He's almost about to throw a party on the other side of things. So please, if somebody could call the Sundowns team and tell them to score for my sake, please. 0800 142 446. That's the number to dial in the studio if you want to be chatting to us here. And it's a big thank you to Mr. Joe Makume, Senior Legal Administration Officer at the Department of Justice, together with Lieutenant Nikiwe Hwayane, coming from the South African Police Services. So call us and ask us any questions that you might be having with regards to the Child Justice Act. Talking about the length of detention, Nikiwe, how long can a child remain under custody?
It shouldn't be a day. 24 hours would be too much. So within that 24 hours, we should have gathered enough information to make sure that the child appears before the court. It should be, and when we say within 24 hours, we don't say the child can appear before the court on the 24th hour. If it's 2 hours, that's it. If we can avoid it, we avoid it. That's the lengthy part of it, only 24 hours.
Does it depend on the type of the offense or not?
Yes. Like I said earlier, there are offenses that, for an example, a theft, there's no need for a child to be arrested at all whatsoever. But when we speak about serious crimes, like it was alluded to earlier, your rape, your murder, your hijacking, your robbery, and then, yes, we can consider, while we're gathering the evidence, while we're getting the statements, and yes, the child can be, but as a last resort, as I said, as a last resort.
What do children living on the streets have to say? You're probably asking yourself that question. Well, let's hear this clip.
Any of you, if you are arrested, why were you arrested? Were your rights read to you? Did you know your rights?
Salega tshwara ma ka me ya ka me ka 24 bangara mo sturuweni mo la ke tsamaya ba fitla ba ema mo la ba researcha ba so searcha ba kreselo kan bona ba tshwere patsi mo la ba re nna ke la tlile patsi mo fatshe. Then bantsi ya bankisa police station ne le satarata ya re sonta mantare ya khoto ba fitla ba re 60 days in prison or 1,000 bay na ga ba botsa ga ke bereki a ke ne chelete yo nga bila ga yona ba re se tsalang wena re tshwere ka patsi ke re na batho ba le bankelele ke sene selo and then ba mpointa ka ntho ke sa ira mo bana ke at the end they felt like le full tracker go spantiti ka nna die 2 months ke sa ira se.
Is there someone who wants to say something about that?
Yeah, nna le nna bothata bo teng ka maphodisa go tshwariwa ba ntshwere ka June. So ka mokgwa ba ntshwere mara June bana le nna ba ntshware ka patse le re patse ne sa tsubi ke nna ne tsuba ke tshumi ya ka so tshumi ya ka mokgwa rala a tshaba maphodisa a tlhaela ba salan ba ntshware ka patse le sino ba ntshware ka patse la phodisa le tsang le lwa le nna ne le bushio he le lwa le nna ba le thapisa dikobo tsaka welo thapisa dikobo ka motlohela sharp o ya le nna police station o fitla police station a sike mmonte le sefane taimane o ngwadisa sefane sa ka ke chabalala hayibo so right ka mmota ke re nna sefane sa ka se chabalala sefane sa ka ke culo taimane ha no cancela chabalala yena sharp ka bosane bua khoto ku khoto kwa le ba re nna ngwadisitse difane tsa maka ba mphanitsheta taitene a re sefane sa ka ke chabalala and then sefane sa ka sa nnete ke culo ba etsa ba mfa 2 months in prison ba nkisa ga ipopetjana so in that 2 months ke ntse ke complain ka yona ntho a ona maphodisa na na itse re ntabe ya re sefane seo a se sa ka nyingi bona ba no potso re se salang go tshwera.
If you can pick up from that clip, one of the most important things that I found that was very interesting there is the whole thing about bail and legal representation. It's something that I would like you to talk about there, Nikiwe. But before we do that, let's take a caller. And he's calling from Val. Is it his?
Yes, he's speaking. Hello.
Yes, good evening to you. Can I ask you to please shut down your radio so I can help you properly there? I'm just hearing myself in the background.
Is that better?
That's 100%. Go for it. What's on your mind?
Thank you very much for this informative program. And I was reading on the news today about a child, a 10-year-old child, who raped an 11-year-old child. And it's a 10-year-old child raped a 7-year-old child. Now, my question is, since both kids, both of them are children, how then do you tackle such a case? The little boy who is 10 years old is taking to their both children. But there's a gentleman who was speaking just now saying that maximum 24 hours that the child must stay in the police custody should they be involved in anything. So now, in the case of a rape, a little boy raping another little girl. How should such cases be handled?
All right, thank you so much, Hisa. I was battling to hear you there. I wonder if any of our guests... did you guys hear... Nikiwa, you didn't hear that, eh?
No, I didn't at all.
Joe, did you pick that one up?
No, I didn't.
Yeah, we were also battling to I wonder if our producers can maybe get a hold of him back and let's try to get a clear line. I wouldn't want him to go away unhelped. 0800 142 446 13 after 8 o'clock. It's a very good evening to you. My name is Kara Balance and I'm glad and excited to be in your company. At least you'll soothe my pain because my team is losing. And while we're at it, we're talking about the Child Justice Act. That's Act number 75 of 2008. And batho ba bantsi ba na le dipotso tse dingata mabapi le Child Justice Act. Mhlomongwe motho ko wena ga o itse gore o ka thusiwa kae. Mhlomongwe go na dilo tse eleng gore you don't understand them really, so we're here to help you. Ongashaya ucingo lapha emsakazweni 0800 142 446 inombolo yethu yokushayela lapha ungayenza kanjalo sizokusiza to the best of our ability. So do that 0800 142 446. Big ups to the two guests that are joining me by way of telephone. It's Joe Magume together with Nikiwe Hwayane. All right, the bail and legal representation. What rights do children have as far as these are concerned? We heard a clip now, and one of the children was actually complaining about the fact that when he was taken into custody, he gave the correct surname, but the police officer insisted on a different surname. Now, something like that wouldn't happen if somebody has legal representation. So, how does it work as far as legal representation, as far as children are concerned?
Okay. Can I respond first, and I'll let Mr. Makume to finish off?
Go for it, Nikiwe.
Thank you. What I could pick up from what the boys were saying was that when they got to court eventually, the other one was given 2 months. The other one was expected to pay 1,000 rand. Part of the investigation that we do is to ensure that the child that we are arresting is the age that he alleges to be. because sometimes a person would be saying, I am actually 17, and we need to verify that, because if the child is not 17, or the child looks, these kids these days, they look big, we need to verify that. And for us to take the child all the way to court, we must have verified that this is not a child, this is actually an adult. For legal representation, the child has got, because one of the things that we have to do is to inform the parents of the arrest of the child. And if the parents feel that they need a lawyer, the child is allowed to be represented from the onset. As to the bail, if the address of the child, the name of the child, and everything can be verified, I'm talking about not necessarily a child now, a person that gets to be arrested, we give the child, this adult, 496, that is a notice to appear before the court. What I'm trying to say is that arrest is not a punishment on its own. We arrest when we arrest adults. We arrest them simply to ensure that they appear before the court. But if an adult commits a crime, and there's chances that this person, the address that she's giving us or he is giving us is verified to be correct, and the name is correct, there is no reason whatsoever why the person has to stay behind bars. The person can be released. In the case of children, we don't even have to go as far as arresting, as far as doing all this. Like it was said earlier, we consult with the probation officer. The probation officer will do an assessment earlier on. And the legal representation, by virtue of that probation officer being there, it does not necessarily mean the legal representation should not be there. The simple truth is that there is no case for this child. There needs to be an assessment first to check the legal, the mindset of the child, whether the child, they know all these things, the probation officer, that they're doing when the child has been arrested, whether this is necessary to be taken to court. Why would you need a legal representation if the probation officer can decide that this is not even going to go to court? But I'm not going to stamp on it. I'll let Mr. Makume to finish it off.
Mr. Makume, do you want to jump in there?
Yes. Look, we have a constitution in this country, and it is the supreme law of the country. So in terms of Section 35 thereof, it is very clear that people who are suspected and have been arrested and charged for whatever offense have a right to legal representation. And then anyone who indeed needs one, unfortunately cannot afford. Like in this case, if you're speaking to street children or children who live on the street, then they need to make an application. Upon a first appearance, their rights are explained through and thoroughly to them by the magistrate, and then they have an option. Either they choose to represent themselves, or they say their parents will afford, and then can basically get a private attorney for them. Alternatively, they can then apply to legal aid if they do not have money to can basically pay for their own private attorneys. And then in this regard, because upon first appearance, the parents or a guardian of that particular child who had been arrested will be in court. She or he will also be asked by the court whether they confirm what the child is saying. Say, for example, the child will have said, no, my parents will afford, and then I want a private practitioner, I don't want legal aid. Then the parents or the guardian will be in court, will then be asked the same question whether he or she confirms the availability of funds to can afford a private attorney. And then if the parent says yes, we have the means, so be it. The court will then afford them an opportunity to then go through the particular process to engage a private attorney to come and represent the child. And then if for one reason or another, as the matter proceeds, if the matter then finally has to go on trial, then the funds dry up and then the parents cannot then afford. Then the court will also engage both of them to say, now that the funds have dried up, do we still need legal representation? And then if so, then the court will afford them an opportunity to go and make an application to the Legal Aid Board or Legal Aid South Africa for the provision of a legal representative. If maybe there had been some evidence which was led, and then unfortunately the new practitioner would not basically know what has transpired in that particular case. Say, for example, the child is in a single or is only accused in that particular case. There will have to be a transcription of the record at state expense, so that the attorney will then come in as a new practitioner in that particular case, can then be afforded an opportunity to basically appraise himself of what transpired in his absence, so that as and when he takes on that particular case going forward, then he would know what evidence has already been laid, and then if he have some questions that he needs to clarify or need to ask some of the witnesses that would have testified earlier when he was not there, which he feels strongly that they might take his case or the accused case or the child case somewhere, then he will have afforded an opportunity to can then recall those particular witnesses so that he can then clarify some of the issues that might have been left unattended by the previous practitioner. So there's an opportunity. If you cannot afford, then you can apply, and then legal representation will be afforded to you at the state expense through the Legal Aid South Africa.
21 minutes after 8 o'clock, give us a call. 0800 142 446. We're talking about the Child Justice Act. Now, on the 23rd of July 2012, if you can remember very well, Orlando Pirates offered the Zimbabwean striker Takashore Chinyama a 3-year contract, and it looks like it was a very good thing they did, because it's working out for them. Pirates 2, Sundowns 0. And second goal being scored by Chinyama there. So we'll keep you updated with regards to that. I think we're coming up to half-time, if it's not half-time at the moment. But don't move an inch. Don't try to go watch the match. I will definitely keep you updated here. Ahis, you're back. What is your question?
Hello, good evening.
Good evening. I can hear you clearer now.
Thank you very much. My question was, but when a child commits an offense against another child?
Uh-huh.
This morning I was reading the news on Sowetan online. There was a 10-year-old boy who raped a 7-year-old girl. In a case like this, how does the law treat a case like this, where a minor commits an offense against another minor?
I think that's clear and straightforward. Thank you so much for that.
Thank you very much.
All right, child minors offending, or how can I put it? Offenses between minors. Let me put it like that. How does the law treat this one here? What does the Act say about this? The example given by the article that was in the newspaper this morning about a child that was 10 years old offending a 7-year-old child. How do you deal with it? You want to jump in there and tell us about it, Nikiwe?
Yes. I think much of that was discussed earlier, but we'll reiterate. A parent will probably be the person that says, I am going to the police to open a case against this child that did this to my child. We do not turn those people away. We do open this case, and we make sure that we call in the probation officer way before we get to meet the alleged the offender. So what we do, we take the statement of the parent, and we get to interview the child. And when we call the probation officers will come on board, and they are the ones that will go to the child that is said to have committed the offense, and it will be taken from there. Datemaku.
Yes. Can I also come in there?
You're more than welcome, sir.
Yes. According to the caller, unfortunately, I haven't seen that particular story in the newspaper, but then say, for example, as CS indicated, the child is age 10. What then happens is, remember, this particular Child Justice Act, because it's created a criminal justice for children, it differentiates between 3 categories of children. There are children who are below the age of 10, whom the law considers to lack criminal capacity. In other words, they cannot be arrested for whatever offense that you, as an adult or as a victim, would feel they need to be arrested. Then there's another category of children between the age of 10 and 14. That particular category of children, the law or the principles that applies to them, they are presumed to lack criminal capacity until the contrary is proven. In other words, what it all says is that it is now the responsibility of the prosecutor who represents the state in that particular case to now prove to the court that this particular child knew what he or she did or he was doing then, and he could or she could appreciate the wrongfulness of his or her own conduct and act accordingly. In other words, to simplify it better, is that the court or the prosecution will then have to convince the court or to prove beyond a reasonable doubt that this particular case, this particular child, having assaulted a 7-year-old, knew that that was wrong. And then her conduct after that particular assault was tantamount or was equivalent to saying, yes, she knew that she made a mistake. She was not supposed to the way she behaved, the way he behaved after having slapped the 7-year-old was very much indicating for the fact that he or she knew that that was wrong, and then it was basically against the law. And then we have another category that is now children between the age of 14 and 18. Those particular children, then the law, there's no presumption in favor or in their favor. The law is very clear to say no. Then they are matured enough to can make a decision in terms of whether to commit an offense or not. So those particular children, upon a complaint being laid against them, they can then be arrested by the police, and then will then appear before the preliminary inquiry or in a child justice court, and the normal criminal process will then follow. So in this case, if the child, the fact that the child is 10-year-old does not necessarily mean that this particular child then would basically it can be said that he or she appreciated the wrongfulness of a conduct. It is a duty that the law places on the state prosecutor to prove that that particular child had the necessary intention to commit the offense. And then as soon as the prosecutor has proven that, then the court or the matter will then unfold in through the normal process of our court.
27 after 8 o'clock. Very, very short, Patko.
Abuti ke khudile ke lebo ne ke batla go botsa bontate ntate le mme ka mono ke na le potso fela ke mdika ba pedi ne ke batla go botsa ona le punishment tsena go mano di a etala sekolong di corporal punishment man sekolong go mano bana ba wo tluwa mhlomong ngwana o na le mathata ka tsoga etsa mosebetsi wa sekolo go mane gore no mistress ka mane ka sekolong kapo teacher wa mo punisha e ka ba hello yona corporal punishment e ya tsamaelana le molao ona re bua ka ona today. Then putwa ka bedi is similar to this one. Ke batla go tseba gore ha ebe motswadi o punisha ngwana hae mane ka tlong ka gore ngwana yena o tsamabtsiu a gutse ka nako sekolong hape le lapeng a ebe o tse o gutse ka 4 ka tlhoga be a le jarting o fumana gore no yena o gutla ka bo 7 ka bo ka 8 and then motswadi a mpanisha ngwane o na le tukelo gore a buele motswadi wa hae nyewe ke a leboga holo karabo le mme ka mono le ntate ka gore no le re information yena ka letsatsi la ka shini ka phepa le letsatsing le tlang re tla bala lo fitisa ke a leboga holo.
Thank you so much, Patko, all the way from Aliwal North. Let's keep this one very, very short. We've only got 1 minute to go, and we don't want to be spending some time. Maybe you can jump in there, Nikiwe. Corporal punishment at school, as far as I'm concerned, in 94 or 95, if I'm not mistaken, the corporal punishment was abolished. Now, what does the Act say about it?
When you look at the Act, it speaks about the child being the offender. In the case Yantate Patko afetsang gore founela hona jwale, an adult o shapile ngwana. Therefore, ha ngwana fitla hae mme wa hae a fumana ngwana shapuwe, mme wa hae o tla police station ngwana wa hae o bula case. An adult will be arrested as your normal arrest because it's not a child that offended. Child Justice Act, it speaks about when the child is in conflict with the law. Same as ngwana ka tlung ha mme wa hae a mo shapile. On the same note, the parent happens to be the suspect. The parent happens to be the offender in that case. Therefore, it does not speak to the child justice per se. Child Justice Act speaks to haile ngwana a shapile.
Yeah, no. Kaniti, you are correct, Lieutenant. Child Justice Act speaks to child offenders. That is now children who are in conflict with the law, and not vice versa. If it's an adult, in this case, the teacher or the mother or the parent at home, then the Criminal Procedure Act comes into place. You are correct, Ntate Karabo, to say corporal punishment has since been abolished. So the statute has not changed. We're still basically on the very same path to say corporal punishment is outlawed, and anyone who then punishes the child in this way then is basically opening him or herself to possible prosecution if the child decides to lay a charge against him or her.
But in other words, you spare a rod, you spoil a child. But however, you could get into trouble with regards to that. So parents, just be very, very careful with that. That's the voice of Joe Makube. He's the Senior Legal Administration Officer at the Department of Justice, together with Lieutenant Nikki Wehwayani from the South African Police Services. It's a big thank you to you for having made some time to chat to us. Please enjoy the rest of your evening.
Thank you. Thank you very much.
From myself, Karabalans, Nikiwe, Joe, please stay on the line. My producers would love to chat to you. Please stay on the line and they will do likewise. So from myself, Karabalans, that's all I had for you for this evening. It's quite it's a sad evening for me. I'm going straight to bed. I'm not answering my phone. If you know my phone number, you're trying to call me at this point in time, you will realize that my phone is off. I'm not answering any messages from Facebook whatsoever because I'm going to be mourning, you see. 2-0. Mamelodi Sundowns going down. Nil. And the Orlando Pirates giving them a hiding with 2. So, yeah, that's what's happening this evening. So, from myself, Karabolans, Wallace Sun Downs. Until we meet again next time.
Anything you want to say before we go?
My name is Piwe Chulu. I'm living at Arangua. So people will let them more couple my advice. Kiore, Cecilente Molfatimo. Kinaga regret to so Kaufela Runa. Reconobasha, when it's
my name is Godfrey, and my advice to the teenagers is that Korbasali peer pressure, Batomabatana Mara drugs, Korbatana Mara Matata, we don't indeed as the Vakasi survive the so stay away from drugs. So
my name is Moses Malulega and Mamelodi. So Nanga Tavelo Lore Machitawa letting Contrequa, H. Bafitur Nartenstegamara, the Taraxi, Rapalwa, Netan Nyaga to so lenetiste Lutletiana, the Savela, Legouts and Lamodi Taraxi, and 2 goats, Idiparas.
My name is Justice Mata. I stay in Harankuwa. My advice is go to Vanava Vanyani, we are in danger place. It's one of the